Judgment in the matter of Gatwick Investments and Bath Racecourse against Liberty Mutual Insurance.
Lord Hamden will explain the Court's decision.
A number of businesses suffered losses as a result of the COVID-19 pandemic. Many of them had business interruption insurance policies. In its January 2021 judgment in Financial Conduct Authority against Arch Insurance, commonly known as the FCA test case, the Supreme Court decided a number of issues about how such policies apply to financial losses related to COVID-19. This appeal raises a further issue, namely whether savings clauses, often found in those policies, require credit to be given in calculating the amounts payable by the insurers for furlough payments received by the policyholders from the UK government under the Coronavirus Job Retention Scheme. Savings clauses typically provide that if charges or expenses of the business which are payable cease or reduce in consequence of the insured incident or damage, then that sum shall be deducted from the final amount payable. The appeal is concerned with two such clauses, both of which are based on standard wording published by the Association of British Insurers. Both the High Court and the Court of Appeal decided that the furlough payments received by the policyholders fell within the savings clauses and had to be deducted. The policyholders now appealed to the Supreme Court, arguing, first, that there was no reduction of charges or expenses, as the wages and other employment costs still had to be paid by the policyholder before being reimbursed under the furlough payment scheme. That is the construction issue. And secondly, that as a matter of law, the furlough payments were not caused by the insured peril and were therefore not in consequence of it. That is the causation issue. In its judgment, the Supreme Court unanimously dismisses the appeal. The judgment is given by Lord Leggatt, Lord Burrows and myself, with whom Lord Reid and Lord Briggs agree. On the construction issue, the Court holds that as a matter of language, the savings clauses could be understood as referring to whether a charge or expense is reduced as a matter of fact, as the insurers argue, or whether the liability for a charge or expense is reduced as a matter of law, as the policyholders argue. Either construction is a possible meaning, but the Court considers that the insurer's construction is to be preferred for a number of reasons, including the following. First, a reasonable person, when interpreting savings clauses, would not differentiate between a policyholder paying a charge and expense and being funded or reimbursed for that payment, and the policyholder's obligation to pay the charge or expense being waived or paid on its behalf by another person. Whilst the mechanics may differ, the economic outcome for the policyholder is the same. The insurer's construction of the savings clause reflects this reality. Secondly, the general context is policies which are concerned with the economic effects of insured perils on the policyholder's business. As such, a savings clause would be expected to be concerned with the economic effects rather than the legal mechanics of the furlough payments. Thirdly, the specific context is that the purpose of a savings clause is to prevent over-indemnification of the policyholder. This purpose is best served if all factual savings are taken into account, not just reductions in legal liabilities. Fourthly, it is both permissible and correct to consider the indemnity nature of an insurance policy when interpreting its terms, provided the policy language does not require otherwise. The policy language does not so require in this case, and where, as here, there are two possible meanings of a clause, it is appropriate to prefer the meaning which better fits the purpose of indemnification. Fifthly, the insurer's interpretation is patently more commercial, whereas the policyholder's interpretation would lead to arbitrary and uncommercial results. On the causation issue, the Court holds that there is a straightforward causal connection between the business interruption losses falling within the insurance cover and the savings from the furlough payments. The The predictable and direct consequence of the insured peril was that the policyholder instructed employees to cease work, but continued to employ them while claiming reimbursement of the costs of doing so. The expenses of employing the relevant employees were thereby reduced by the furlough payments, just as they would have been if the employees had been made redundant. The sums saved were caused by the insured peril and were therefore in consequence of it. The first ground on which the policyholders argued otherwise was that the occurrence of the insured peril was irrelevant to the entitlement to furlough payments, as they would have been entitled to claim and would have received furlough payments even if the use of their premises had not been prevented or hindered, and irrespective of whether any case of COVID-19 had occurred within 1 mile of those premises, that being the insured peril. This argument assumes that to establish the required causal connection between the furlough payments and the insured peril, it is necessary to demonstrate that the payments would not have been received but for the occurrence of the insured peril. The Court rejects this argument for 2 reasons. First, it is inconsistent with what the Court decided in the FCA test case, namely that to show that business interruption losses were caused by an insured peril, it is not necessary to satisfy a but-for test. The sole test is one of proximate causation. Logically, the same test of causation must apply to the causation of savings as applies to the causation of losses. Secondly, the policyholder's case is internally inconsistent, because to recover their business interruption losses under the policies, they themselves need to rely on the rejection of the but-for test and on the analysis of causation adopted in the FCA test case. The second ground relied upon by the policyholders was that the furlough payments were gratuitous, benevolent or voluntary collateral benefits conferred by a third party, which are not to be regarded in law as caused by the insured peril. The policyholders relied on a series of cases in which courts have considered whether or when payments received by the policyholder from a third party are to be treated as reducing the loss against which the policyholder is entitled to be indemnified by the insurer. After examining these cases, the Court finds the law to be that any payment made to the policyholder by a third party in respect to the subject matter of the insured loss, even if made voluntarily or gratuitously, will diminish the loss and reduce the insurer's liability, except where the third party intended to benefit only the policyholder to the exclusion of the insurer. Applying this principle, the furlough payments paid to the policyholders reduced the losses insured against. There is nothing in the terms of the coronavirus job retention scheme or the surrounding circumstances to suggest that those payments were intended to benefit only the policyholders to the exclusion of any insurer liable to indemnify them for business interruption losses. The Court also rejects the argument that furlough payments, as a matter of principle, ought not to be regarded as caused by the insured peril because they were voluntary, gratuitous or benevolent and were therefore collateral benefits. Furlough payments cannot be characterised as voluntary donations because, under the terms of the scheme, policyholders who met the qualifying conditions had a legal right to receive the payments, and the UK government had a legal obligation to make them. Nor can the furlough payment scheme be characterised as a voluntary, gratuitous or benevolent intervention by the UK government. There were benefits to the government and to the public at large of reducing disruption to the economy and incentivising business to instruct employees to stop working to help reduce the spread of infection. The scheme was not an exercise of gratuitous or benevolent giving.
The Court will now adjourn.